All right, good morning, everybody. March the 10th, the year 2017. Gary Hunt has a website, Outpost of Freedom, and there's 6 articles written about Schuyler Barbeau. And so I'm going to go ahead and read through all 6 of them, but I thought I would just turn on a recorder, record myself reading it, and put it on YouTube to help spread the word about making noise and shining light about the injustices going on in the case of Schuyler Barbeau. He spent over a year in a holding center and hasn't even had trial yet. So we've read some letters. We've read some letters from Schuyler Barbeau, but these are articles that are written by Gary Hunt, I think. And let's go ahead and read them. And we've got 6 of them to go through. So over the next few weeks or days, as I get time, I'll read all 6 of them into YouTube. This one is titled The Arrest of Schuyler Barbeau. It's dated December the 9th, the year 2015. Gary Hunt, Outpost of Freedom. In the late morning of December the 6th, 2015, Schuyler Barbeau had been helping Allen Inc. by rescuing service dogs as a business service run from the Inc. family ranch in Stevens County, Washington, some 280 miles away from where the following events began to unfold. After dealing with the dogs, Schuyler wanted to stop to collect some money owed him by Oliver Murphy. Murphy texted to Schuyler to meet him at a way station at Interstate 90 and Washington Highway 18 between Preston and Snoqualmie. When they arrived at the way station, Oliver's car was there, but Oliver was nowhere to be seen. So they parked next to Oliver's car, and Allen got out of the car, cell phone in hand, to call his wife and to take the dog to the dog walk. Before he could complete his intended task, he saw between 10 and 12 battle-dressed people encircle him and the car. He was told to lie down on the ground. He complied, though he questioned why they were being treated this way. They then handcuffed Allen, and since Schuyler was on the other side of the car, he didn't really see what happened to him. Allen did note that he saw FBI, U.S. Marshals, and Coast Guard, though there were no apparent BATF agents on the scene. But we'll get to that. We'll get to the charges shortly. The agents were going through his car, but they had no warrant with them. They simply stated that they did have one. There was a warrant to search the car at the premises ranch, but nothing identifying the car specifically. They then moved Allen away from the car and began asking questions about Schuyler, but were told to ask Schuyler, not him. After they had searched the car, one of the agents, acting rather rudely and assertively, asked Allen to sign a receipt of property seized, which Allen refused to sign. And Special Agent Kara O'Reilly, did you ever wonder why GIMP kids are special and so are FBI agents? Affirmed that he refused. However, he was provided a copy, and it shows the following items seized from the car. Green, Bad Incorporated vest with visible firearm magazines with unknown contents inside, pockets, bags, etc. Gray universal bag with yellow straps with green sunglasses on strap and unknown contents. FNH VSA pistol FNX-45 tactical serial number FX3 U02 5994 with intelligible. Enforced tactical light 1 round loose 15 in magazine full metal jacket 45 caliber. Cellular telephone Android platform. Droid Turbo with other box, gray with yellow outline. Allen was not allowed to verify some of those seized items. In particular, the gray universal bag with yellow straps, so the feds can do anything they want with the contents. It was Special Agent O'Reilly who rather rudely refused Allen's request to review the contents. Just so we know who the rather rude agent that dealt with Allen is, she was Kara Wolbert, and may have been Kara Wolbert Wagner prior to that. Around 2013, she married Brendan Gerard O'Reilly, age 46, and claimed her house at 2914 South Hill Street, Seattle. to herself and her new husband. Enough of that, so on with the show. The other special agent was Matthew Acker, who acted courteously, as we should be able to expect our public servants to act toward us. The two agents were apparently assigned to Allen. While we can suppose that the rest of the jackboots were needed to assure that Schuyler didn't take over the surrounding forces, though we will get to that information from him when he is removed from sequestration and allowed visitors and phone calls. The criminal complaint. Though we had no proof of the existence of an arrest warrant being issued prior to the arrest, we do have the criminal complaint that resulted in the arrest, as well as the search warrant. The only count in the complaint says that Schuyler knowingly possessed a firearm which was not registered to him in the National Firearms Registration and Transfer Record, as required by law, namely a particular black semi-automatic AR-15 5.56 millimeter caliber assault rifle with a 10.5 inch barrel and holographic sight, a rifle having a barrel of less than 16 inches in length, for which the government wants a $200 tax. The refer to Title 26 U.S. Code Section 5861D and 5845A3 as the violations. Title 26 is the tax code, so they are assuming that Schuyler owes a tax and that he failed to pay it. Can you imagine how much it costs the government to persecute Schuyler as opposed to, say, sending him a bill? It appears that what he had was a Rainier Arms Ultra Match .223 Wild Complete Upper 10.5. This is advertised by Rainier Arms, and the ad states that all NFA rules apply. So we know and understand that a Class 3 license holder has, by obtaining the license, agreed to do certain things. Among them would be to verify that if he sold such an item alleged to be illegal in the complaint, he would have to run a background check, provide the necessary paperwork to the purchaser, submit the paperwork, and fulfill the duties that the regulations require of him. But that is because he contracted by obtaining the license with the government to perform those tasks required by those regulations. This would include 18 U.S.C. criminal and 26 U.S. code tax and perhaps others. But it is only the licensee that has agreed to abide by those regulations. However, the Second Amendment has confirmed our right to bear arms without infringement. This leaves the government with only limited jurisdiction via the Commerce Clause, interstate commerce, and the taxing authority as the means of the government to try to circumvent the limits imposed upon the government by the Constitution. However, if someone hasn't contracted with the government, they, as well as the government, should be bound only by the Constitution. Schuyler's right to possess that firearm is sacred. There is no justification for the government to attempt to, by force of arms, pay a tax on that right, regardless of what the government thinks, and it is his right to do so that we, the people, need to support and defend. Back to the complaint. Special Agent Michael Baldino executed the complaint. He is a member of the Seattle Division's Domestic Terrorism Squad of the Joint Terrorism Task Force. Those are the guys that let Muslims kill people in California while they mess with Americans that are intent on defending America against those Muslim terrorists, and BLM, Bureau of Land Management wannabes. In paragraph 5, page 3/6, we see that a confidential human source provided information snitched to the FBI about Schuyler. The complaint is a substitute for the constitutionally required affidavit, and a poor substitute at that. An affidavit is sworn as to personal knowledge and is not supposed to give any validity to hearsay. However, since Baldino didn't swear to the document, well, he can say anything he wants. Back to the confidential human source. It has been confirmed that the confidential human source in the complaint is none other than Oliver Murphy. Yes, that is the one that baited Schuyler and Allen to the way station, but it doesn't end here. Before we proceed, perhaps we ought to look at Mr. Murphy. His father, Patrick Murphy, was Snohomish County Sheriff. He was appointed to that position in 1995 when then Sheriff Jim Scharf stepped down to become the Everett Police Chief. Murphy, however, didn't stay long. He was charged with 4 counts of felony possession of prescription medication. Patrick died in 2006, so maybe Oliver wanted to follow in his father's footsteps and become recognized in law enforcement. At any rate, Oliver was in from the beginning to the end of Schuyler's ordeal. Paragraph 7. complaint tells us that confidential human source was invited to the trailer that Schuyler was staying at in the Ank Ranch on October the 19th, 2015. The Anks have confirmed that it was Murphy that stayed with Schuyler on that date. There is only one confidential human source. If there are more than one, they are numbered. So it is Murphy in every instance in the complaint. Next we have Baldino going to Facebook to see what dirt he could get on Schuyler. He found photographs where Schuyler acknowledged that he owned a short-barreled rifle, SBR, which would be the Rainier Arms Ultramatch. So when Schuyler suggested that he wanted to sell it, Murphy, being such a nice guy, let Schuyler know that he had found a buyer for the SBR. On November 22nd, Schuyler dropped the SBR off at Murphy's residence. So now Murphy possessed the SBR, but he has not been charged, and according to the available information, he is not law enforcement, nor is he exempt from any regulation that might be imposed, legally or not, on Schuyler. But Murphy was never charged with a crime. But then that is the nature of a police state, isn't it? Schuyler has given up the SBR. Schuyler has given up the SBR. Murphy gives it to the FBI, but nobody has paid Schuyler for the purchase. The SBR. That sounds awfully like what is commonly referred to as theft, fraud, swindle, or some other real crime that has an injured party, namely Schuyler. But in this modern world where it is always somebody else's fault, the only one that didn't hurt anybody by stealing property was Schuyler. It was probably to collect the money that Murphy was supposed to have sold the SBR for that was the enticement for Schuyler and Allen to go to the way station. Meanwhile, back at the ranch, about the same time that those events were occurring at the way station across the state in Springdale, Carrie Ank was facing her own ordeal. The following is based upon an interview and documents that have been provided. 30 to 35 people showed up in 7 to 8 vehicles. Carrie, when she saw them driving in, tried to call Allen. There was no answer. However, they used a battering ram on the back door of the house. They also released some of the dogs from their kennel. The search warrant is marked X in the daytime, 6 a.m. to 10 p.m., page 1 of PDF. It says nothing about no knock, so it must be served in a civil manner. A battering ram at the back door of the house hardly satisfies that expectation, but then when you give thugs a license, they can do as they please, the Constitution notwithstanding. I think we need to note here that the search warrant, among other things, states that I find that the affidavits or any recorded testimony establish probable cause to search and seize the person of property. However, no affidavit or recorded testimony has been provided, and if we were to assume that the criminal complaint somehow satisfies that requirement, then even more curious is the fact that the search warrant brings in charges that were not included in the complaint or anywhere else in any of the currently existing court documents. As far as the warrant, it gives permission to search for the person or property described in Attachment A. Attachment A says, the warrant authorizes the search of Schuyler Pyatte Barbeau for any cellular phones. The warrant authorizes the search of any such phones for the items described in Attachment B. Then it remarks that Schuyler resides in a trailer on the property. So the warrant only allows them to search Schuyler for any phones, and then to search any phones for items in Attachment B. So to make this clear, Schuyler can be searched for phones. Presumably, if phones are found, those phones can be searched for the items identified in Attachment B. There doesn't appear to be any authority to search beyond that limitation. So let's look at the Attachment B to see just what might be found in the phones. Attachment B begins with items to be seized from the phone described in Attachment A. Before we continue with Attachment B, let's reflect on what they just said. The items to be seized are to be seized from the phone. I know that the concept of seizing items from a phone is difficult to digest, unless of course you are a government agent. I realize that smartphones are a bit over my head, but I still have a problem understanding how items can be seized from them. But let's continue and see just what those federal agents can seize from a phone. Continuing in Attachment B, all documents and items reflecting an evidence and or fruits of the commission of crimes, unlawful possession of a firearm in violation of Title 26, United States Code, Section 5861D and 5845A3. B, possession of stolen federal property in violation of Title 18, United States Code, Section 641, and possession of a machine gun in violation of Title 18, United States Code, Section 9220, including. Then it goes on to list not items, rather telephone serial numbers, sent, received, and missed calls, stored contact information, and any stored photographs or Facebook post that might show something illegal. This brings to mind an important part of the Constitution, where they itemize some of the inherent rights of the people, not as grants by the government, rather prohibitions against the government violating them, specifically the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So if information stored in a cell phone, since it can't be items that were to be seized, is simply a modern substitute for papers and effects, then it requires that the probable cause must be supported by oath or affirmation. Unfortunately, the government has failed to provide such. The complaint was for a tax violation only, and being singularly concerned with that SBR, if we assume that the affirmation, that is really stretching our language to an extreme, then the extent of that affirmation must be limited to the SBR and Title 26 taxes. So where the hell does possession of stolen federal property and possession of a machine gun come into the picture? Do this judge make this SHIT up while sitting around the water cooler? Also consider the judge, Thomas O. Rice. Does he even read what he signs? And all of these idiots, even the judge, probably make over $100,000 a year of our money. It seems more like the mafia than a government. Just throw a little confusion into the mix. Both of them attachments mentioned above the bear, the case number directly below the title. There are two more attachment A's, but neither of them have a case number, so they are either sloppy, inserted these from some other source, or they could care less about the identification of legal documents. Take your pick. But when you are dealing with incompetence, it can only be a wild guess. Given the limits of what could be searched for, let's look at what they found on the phone. Number 1, plastic bag with .223 ammo. Number 2, 7 .223 magazines. 3, Verizon bill, ID cards, record book. Number 4, Motorola mobile phone, model XT912. Number 5, nylon bag with camping tool and tape. Number 6, plastic box with gun parts. Number 7, large plastic bag with gun parts. It is hard to believe that any of those items, except for number 4, could satisfy the conditions of the warrant. Number 4 was the Motorola mobile phone. However, the act of the service of this warrant after the battering ram entry gets even more interesting. After they entered the house, they flashbanged every room they entered. Carey counted at least 8 of them in the house. That's right, they threw flashbang grenades into each room in order to clear it. Perhaps from evil spirits, since it would be difficult to otherwise understand the necessity of causing intentional damage, including gaping holes in walls, windows blown out, not to mention the back door that was battered open. One hell of a mess to prove that the government has come to help you. If there is an assumption being made here that the government will perform restitution for the damage they cause, especially if the charges are dropped against Schuyler, then you are sadly mistaken. While this search and destroy was going on, Carey was held handcuffed for about an hour and a half, and she was not allowed to contact her attorney. They also held a gun on Carey throughout the entire ordeal. Perhaps there is a reason for concern when there is just one pissed off woman and only 30 to 35 armed men to keep her under control. That's funny. While searching the rest of the premises, they used at least 10 more flashbangs, some of them apparently only to scare the dogs, which resulted in laughter by some of the agents, who apparently were enjoying themselves immensely while terrorizing Carey. I will conclude by stating that this is by far the most egregious abuse of presumed government authority that I have seen since my visit to Waco back in 1993. Perhaps it is time to reflect on whether a truly self-governed nation, or have become subject to a government far more despotic than that one cast off by the founders 239 years ago, and to reflect upon our own obligation as that posterity, identified in the preamble to the Constitution, to assure that this once great nation returns to its intended object for our own posterity. For the follow-up, Schuyler's description of what happened, see Barbeau cued in Seattle, the arrest of Schuyler Barbeau, part 2, in Schuyler's own words. All right, this was written back in December the 8th of 2015, I believe, by Gary Hunt. There are 5 more, so we will work our way through these as we get time. And we will educate ourselves on the case of Schuyler Barbeau, with the objective being to make noise and shine light about what's going on with this man who is still in FDC SeaTac prison. His address is on your screen. I pray that you write him a letter, and keep in mind that he hasn't even been to trial yet, and it's been over a year.